All right, so I missed this when it happened. It's Wednesday, April 30th, about 2 p.m. West Coast time. Last Friday, a judge in El Paso, Texas, a federal judge, so in the Western District of Texas, issued an order, a sweeping order, relative to Trump's use of the Alien Enemies Act. So what had happened? There was a couple. Their first names are Julio and Lourdes. They're married. They have 3 kids together. They and their 3 kids have been living in the United States with temporary protected status since 2022. I believe they are all from Venezuela. They have pending asylum claims. Trump tried to deport the parents under the Alien Enemies Act, alleging that they were both members of the violent street gang from Venezuela, Tren de Aragua. And recently the Supreme Court was like, no, even if you're going to deport somebody under the Alien Enemies Act, they still have rights to due process. They still have a right to a hearing, and the government has to present evidence in support of the allegation that they are members of this gang. And so one of those hearings took place last week in front of U.S. District Judge David Briones in El Paso. He made his ruling on April 25th, and he ordered this couple to be released from custody, and they were. Briones' decision found that U.S. Immigration and Customs Enforcement, ICE, officials failed to provide any lawful basis indicating why the couple should be detained any longer for an alleged alien enemy violation, according to his opinion. There is no doubt the executive branch's unprecedented peacetime use of wartime power has caused chaos and uncertainty for individual petitions as well as the judicial branch in how to manage and evaluate the executive's claims of Tren de Aragua membership and the invocation of the Alien Enemies Act as a whole, wrote Judge Briones. The couple had been living in the Washington, D.C. area for 3 years, again, with their kids under temporary protected status. And during the hearing, the government did put on some evidence, but they were alleged to be members or associates of a foreign terrorist organization. Briones' ruling says the allegations against the couple are based on multiple levels of hearsay hidden within declarations of declarants who have no personal knowledge about the facts they are testing to. In other words, unreliable and inadmissible hearsay. This decision marks the first time that a judge has ruled that the Trump administration had erred in classifying someone as an alien enemy, meaning this appears to be the first order coming out of a hearing where someone accused of being a member of Tren de Aragua by the Trump administration actually got a hearing where the government had to present evidence. And there have been several of those that have happened now, and I have not been able to find one where the government met its burden in proving that so-and-so is a member of Tren de Aragua. They're just rounding up brown people and saying they're members of Tren de Aragua and sending them to this prison in El Salvador. That's all the fucking administration is doing. Anyway, so this is the first time a judge was like, no, you don't have the evidence. It's unclear whether or not the government is going to appeal. But if you have an evidentiary hearing like this and you appeal it, appellate courts don't disturb the record on appeal, meaning that an appellate court is not going to hear new or additional evidence. So the appellate court's going to be stuck with the record that was created at the trial court level during this hearing. And the Trump administration is going to be stuck with that record as well. But this judge went a couple steps further. So remember a couple Fridays ago when there were buses moving around and there was an emergency application to the Supreme Court, and the Supreme Court issued a ruling at 1:30 in the morning, Saturday morning, to prevent those particular putative class of immigrants from being deported. That order applied to the Northern District of Texas. This judge is in the Western District of Texas. And he issued some additional orders that are consistent with that Supreme Court ruling, because the Supreme Court has said people have to apply, they have to file their habeas corpus petitions in the district or in the circuit where they're being held. There aren't going to be any more of these like nationwide orders kind of thing. So that order was for the Northern District of Texas. This is for the Western District of Texas. And Judge Briones also ordered that the government must provide detainees 21 days notice to contest their status, and they must be given notice in a language that they can understand. Because in the Northern District of Texas, the government was giving them 12 hours of notice and providing them that notice in English when the vast majority of those people don't speak or read English. The Trump administration, in a separate case, recently shared a sample notification form in which those labeled as alien enemies were given 12 hours to state whether they plan to contest that designation. The judge also barred the removal of any non-citizen being held in federal immigration custody within his district, which is El Paso, San Antonio, Austin, down to the Mexican border. And in his order, the judge basically was like, you guys haven't provided me with any evidence at all. They had declarations of this person said that person to that person, and I heard from this guy that that person said that 10 years ago, the wife dated a guy who was a member of this gang, and she, moved money around for them. And their allegations against the husband were, well, he's married to her, and she's a gang member, so that makes him a gang member too. That was essentially their evidence. And so when you're in court and a judge is making these determinations, you're dealing with different levels of proof, different burdens of proof. And we've talked about this before, like if you envision the scales of justice, beyond a reasonable doubt is the highest. In the middle, you've got a preponderance of evidence, which is like that much, like 51%. In between the two is clear and convincing evidence. It's not beyond a reasonable doubt, but it's a lot more than a preponderance. And this judge was like, if I take your evidence, it's like, even assuming that Trump's invocation of the Alien Enemies Act, a wartime statute, and he's invoking it during peacetime, even if that's valid, and even if I look at your evidence and apply just a preponderance of the evidence standard, the lowest burden possible, he's like, you still didn't get it done, let alone provide me with clear and convincing evidence. The judge he basically ripped the government up one side and down the other, and told them that they're incompetent and they don't have evidence, and they're lying when they make these allegations with people. And which again, that all comes down to messaging. And we saw that last night in that just batshit crazy interview with Donald Trump with ABC News and Terry Moran in the Oval Office, where Trump is like, he had MS-13 tattooed on his knuckles. He had MS-13 tattooed on his knuckles. And Terry Moran was like, Mr. President, that was photoshopped. That was photoshopped. That was Times New Roman font that had been photoshopped onto that photograph. And Trump stuck with that for 10 minutes. That's what these guys consider to be evidence. That kind of shit. Photoshopped tattoo images. And so Trump and his immigration plans, and I think we're going to see his tariff plans and everything he's doing to law firms, everything he's trying to do to colleges like Harvard, he is running into a fucking brick wall. when it comes to the federal courts. And so I kind of feel like the final confrontation is pretty near at hand, where he's just going to state explicitly, we are not going to follow court orders in this administration. We are going to do what we want to do, and it's up to you to stop us. And good luck with that. So we'll see what happens. So stay tuned.